So good morning, everybody, and welcome in Trento. I'm very sorry I was not here yesterday. I attended with enormous interest and pleasure the celebrations for the 30th anniversary of the Italian Yearbook of International Law that took place in Siena. With other friends and colleagues, we presented the 30th volume of the Italian Yearbook, and at the same time, we introduced the 31st volume of the Italian Yearbook of International Law. But now we are here in Trento. I'm very happy to be home, so to say. And I'm very happy to welcome you all, although I know that yesterday's session was very well attended and extremely interesting, and I thank you also for these. I would like to start by thanking everybody, but I would like to thank the organizers of these very important colloquium, which, as far as I understood, is in line with previous similar meetings that took place all over Europe. I know because I've been following in recent years your activities, but I'm in this field. I'm somehow an outsider. But I really thank also those who came from all over the world. This is the first meeting. I must say that I'm a little moved by the fact that this is really the first meeting we are organizing you are organizing in Trento. I always speak on behalf of others, and I'm sorry if I do this, but I'd like to thank those who came from abroad and also those who came from the rest of Italy to celebrate the restart of very good tradition concerning meetings on a contemporary perspective on international investment law. I think that the organizers and those who are here were brave enough to say that, to think that this meeting could have taken place, because until some days ago, we had also some reservations, but I'm very happy that this is also the occasion to inaugurate, at least on our side, this wonderful room that has been funded by the Minister of Universities funding for the Universities of Excellence we got some years ago. But I'd like now to start on the substance, and I am introducing and I will chair this panel concerning investment arbitration and scientific knowledge. And in order to do this, I spend a few words and then I will introduce the speakers. So I start by saying that science-intensive legal questions in investment arbitration are increasingly requiring arbitrators to engage with scientific and technical knowledge in the assessment of claims. So far, the use of science has played a major role not only in relation to some environmental, public health, and energy disputes, but it is expected to become a key aspect in future investment disputes involving pandemic-related measures and climate change policy. In these proceedings, scientific knowledge will be key, and international guidelines and specialized agencies such as the WHO recommendations and technical documents, they may become an important point of reference for adjudicators, not only to understand the factual background of the dispute, but also to assess the legitimacy and the reasonableness of the measures at stake. yesterday I was reading something, preparing myself for this panel, and I saw that, as you surely know, and maybe you also cited yesterday when I was not here, that the Glasgow International Law Center has started a new project on the topic of investment arbitrations, and a new research topic. And in this presentation, there are some reference to what some law firms are doing as regards the future disputes concerning investments related to the pandemic. I'll say that the entry of science into the proceedings through party-appointed and tribunal experts and the rules presiding their use will become pivotal for the effective management of investment arbitration proceedings and the quality of their outputs. The present panel aims to address these issues and discuss the use of scientific and technical knowledge in investment arbitration. The first speaker, Professor Pertile, will address the role of the WHOs in providing scientific knowledge in investment arbitration. It will particularly focus on the WHO's rules and guidelines adopted in times of pandemic and their impact on investment arbitration. The second speaker, Dr. Faccio, will illustrate whether and to what extent scientific knowledge and information have been employed and are expected to be used in the future by arbitrators in the assessment of states' regulatory measures. The third speaker, Dr. Farnelli, will focus on procedural matters and discuss the rules presiding over the use of experts in investment arbitration. So before giving the floor to Marco, let me say a few words on the participants and on the discussants of this panel. Marco Pertile is Associate Professor of International Law at the Law School and the School of International Studies here at the University of Trento. He is co-director of the journal KIL, Questions of International Law, and visiting professor at the Paris School of International Studies, Sciences Po. Marco is currently working as principal investigator on the project the WHO and its role in the pandemic, functions, limits, and impacts, funded by the University of Trento. Sondra Faccio is assistant professor at the Law School and the School of International Studies. She is attorney at law, admitted to the bar. Her field of expertise is international investment law and arbitration, conflict of law. She has recently published a book, as many of you know, I think all of you know, on indirect expropriation in international investment law between state regulatory powers and investor protection. Gian Maria Farnelli is assistant professor at the Department of Legal Studies of the University of Bologna. His publications address issues of law of the sea, environmental law, state immunity, investment law, and the law of international adjudication. He was a member of the Italian legal team in the North Star case before the International Tribunal for the Law of the Sea, and he has been a research assistant in interstate and investor state disputes. Our discussants will be Professor Eric de Brabandere. And hi, Eric. It's really a pleasure to see you again. From time to time, notwithstanding the pandemic, we are able to see each other, and I am extremely grateful that you accepted the invitation to be one of the discussants today. Eric de Brabandere, as you all know, is Professor of International Dispute Settlement Law and Director of the Grotius Center for International Legal Studies. He's also attorney at law at the Brussels Bar and editor-in-chief of the Leiden Journal of International Law. I am really happy that he was able to make it. Thank you, Eric, and we will see each other later on, also online. Pierre Conci, another old friend of ours, is a professor of international law and international economic law at the University of Teramo, a university that is very dear to me for many, many reasons. She has published extensively in the field of investment law. She's also one of the editors of the Italian Yearbook of International Law. She was not able to be both here and in Siena yesterday, but she's here now, and I'm very happy and grateful that she accepted the invitation to be one of the two discussants. So without further ado, I'll say that Marco will start, and Marco, you have the floor.
Thank you very much, Chair. I will now share the screen. I think I need to do that, right? Okay, with the presentation. Okay, and I think okay, so as said, the WHO's role in providing scientific knowledge in investment arbitration. The investigation, the idea at the basis of this presentation is based on a number of assumptions, or statement of facts, I would say. So an inductive approach is at the basis of the investigation. The assumptions at the basis of the investigation are the following ones. The WHO played a unique role in the management of the crisis. There is an extensive production of recommendations, technical guidelines. It remains to be seen whether those guidelines and documents actually influenced state practice. This is not entirely clear, but the fact remains that the WHO has played a leadership role, has become a point of reference in the debate. This is undeniable, irrespectively of the difficulties, the intricacies of the causal nexus. It cannot be denied that the WHO played a leadership role. At the same time, as we have seen yesterday, the measures adopted by states had a clear impact on foreign investors. So it can, of course, be expected that foreign investors will bring claims before international investment arbitration. So putting together the two statements of facts, the two assumptions, the question is, what do we do of these recommendations and documents? What can be done before international investment tribunals? I just tried to classify or use the classification of the acts adopted. So you see how extensively they cover all of the issues related to the management of the pandemic. So there are several topics covered, from preparedness to coordination, infection prevention, clinical care, and so forth and so on. So the research question is, as said, what use can be made? A very practical research question, starting from these observation of the phenomenon. More precisely, can we use those acts? Can these acts be used as a scientific parameter to assess the reasonableness of the exercise of public powers, or of the inertia of governmental authorities? So can we read, can we understand the inertia or the behaviors of state authorities on the basis of these documents? Of course, as has been seen yesterday, the types of claims can be very, very, very diversified. So interference with the rights of the investor on the one hand, or failure to adequately protect the investor on the other. This is, of course, the main classification in my view. Okay. So in order to investigate the matter, whether these acts by the WHO actually influenced state practice, a first step, in my view, was to investigate and try and read national legislation to see whether national legislation related to the pandemic has been influenced by the acts adopted by WHO. This is a work in progress. This is not very, this is just the beginning and very difficult indeed. What I have found is that generally the role of the WHO and the acts adopted by the WHO are mentioned in the preamble of legislation. They are mentioned as a point of fact to justify the existence of the need to adopt some measures, but they are not directly quoted with relation to the measures adopted. This is what I've seen going through just a limited number of cases. Perhaps the most interesting case is the Italian one, where the decree of the President of the Council of the Ministers of December 3rd, 2020, in some of the annexes makes reference to the guidelines of the WHO directly and in an automatic manner. So the decree says, makes a renvoi, a direct renvoi to the guidelines, and mentioning also the fact that would the guidelines change, reference should be made to the amended version. So this is perhaps the most interesting example so far, but of course this is just the beginning. Another element of practice, which is quite evident, quite manifest, lies in the fact that some recommendations, some documents adopted by WHO are clearly, at least in two fields, in my view, at odds or incompatible, apparently incompatible with the practice of states. And that is the case for travel bans and for the vaccination strategy. So for travel bans, the WHO took the view that restricting the movement of people, as you can see, and goods during public health emergency can be ineffective in most situations and might divert resources from other interventions. So the position of the WHO has been traditionally quite critical of the adoption of travel bans, and that is the case in the present pandemic crisis as well. Of course, states adopted sweeping measures with respect, of course, to travel bans. With respect, we are witnessing this development, but it is quite interesting that, I mean, if you look at the issue scientifically, you generally tend to find a justification also for the opposite position. So my divertissement was to try and find a scientific article justifying in scientific terms exactly the validity of a travel ban. So we have scientific articles justifying the validity of a travel ban. We have the WHO based on scientific studies criticizing a sweeping travel ban as potentially ineffective. This is interesting in my view. When it comes to the vaccination strategy, of course, you see this statement by WHO it's clearly a criticism of vaccination of children and adolescents who are considered to be at low risk when the vaccine coverage in high-risk populations around the globe are not covered yet. So this is the position of WHO, but of course we know several countries are now vaccinating children, and also of course they are providing other people with boosters. So this is you see a statement by the CDC director in the US. Together with science leading the charge, we have taken another important step forward in our nation's fight against the virus. So vaccination of children is justified in the light of science. On the other hand, the WHO is taking a different position. So what is the legal framework? What is the relevant legal framework in sum? I mean, to simplify a bit, the most important document is, of course, the International Health Regulations, as amended in 2005. The objective of the regulations is quite interesting for our purposes, because as you can see, the objective is not related to health, period, but it is related to health with a view to avoiding unnecessary interference with international traffic and trade. So we might say economic interest in general terms are quite present in the international health regulations. When the international health regulations, they make, of course, the case for obligations related to core capacities. So states should acquire core capacities in managing pandemic events, but also other events of interest, and core capacities are related to surveillance and response and designated airports, ports, ground crossing. When there are obligations of notification and information sharing, what is of interest is that the management of the epidemic, of a potential epidemic, is not the object of precise obligation after the determination of course, the international pandemic event, of a public event, health event of international concern. Temporary recommendations can be adopted by the organization, and then additional measures can be adopted by states. So in the management of the pandemic, the WHO may adopt temporary recommendation, but states are still free to adopt additional measures. So this is in sum the legal framework. Temporary recommendations, standing recommendations are a different thing. We are related to issues which are not directly related to the pandemic. And then there are technical guidelines. These are the type of acts and documents which are adopted by the WHO. An interesting point emerging by the analysis of the international health regulations is related to the interaction with other international agreements. So if we asked ourselves in the abstract, are there any issues of incompatibility between the international health regulations and bilateral investment treaties or treaties related to the protection of investors? Well, the answer in the abstract is certainly in the negative, because the issue is covered by Article 57, paragraph 1, according to which state parties recognize that the regulations and the relevant international agreements should be interpreted so as to be compatible. So there is in the regulation this clause, which is clearly applicable to international agreements, bilateral investment treaties. It's clearly applicable in general terms. In 2004, the working group on the revision of the IHR made a number of examples related to possible incompatibilities with the international health regulations. They did not mention international investment law. They did not mention international investment agreements. They made a number of examples on international trade law, the Codex Alimentarius, international environmental law, and so forth and so on. But it is quite clear by reading the document that the examples they made were clearly a part of an open list. So there are no issues in interpreting Article 57, in my view, as applicable to agreements related to the protection of investors. But of course, the issue cannot be solved and tackled in the abstract. The issue is about, of course, the practical application of the international health regulations. And what is of interest, again, for our purpose is that the international health regulations are punctuated with a number of references to scientific evidence and scientific principles. So first of all, we have a definition of scientific evidence and scientific principles. And then there are references to the scientific method at the basis of the determination of a public emergency, at the basis of, as a requirement for the adoption of additional measures by states, which is quite important for our purposes. And of course, then the question is, can we really take the view? I mean, the underlying question in my view is, can we really take the view? The acts adopted or the documents adopted by the WHO and by the states under the health regulations are scientific. What do we mean by scientific? Can we really take the view they are scientific? What can we grasp by reading the relevant provisions? So first of all, you see a definition of scientific evidence and scientific principles, which is probably better than nothing but a circular one, because as you can see, scientific principles means the accepted fundamental laws and facts of nature known through the methods of science. So one needs to know what the methods of science are, which is a question, of course. One can make reference to encyclopedia, dictionaries. Of course, scientific method is about trial and error, is about deductive reasoning, is about formulating hypotheses and then putting such hypotheses to a test. But of course, what science is a huge open question. The difference between science and pseudoscience is a problem in itself. So we have definitions nonetheless. And then if we ask ourselves whether WHO acts are scientific, then of course we might again grasp some elements by reading the relevant articles. So Article 12 is the article related to the determination of an emergency of international concern. And you see that the elements which need to be taken into account by the Director General are diverse. I mean, they make reference to science, available scientific evidence. They make reference to the advice of an emergency committee, which is composed of people with an expertise in the scientific method. They make reference nonetheless also to a flow chart, which is in Annex 2. The flow chart is quite interesting because at some point, you see, in the end of the flow chart, the question posed to the relevant decision for the notification of events which may constitute a public health emergency, the question asked is there a significant risk of international travel or trade restriction? Yes, notification. No, not notified at this stage. So it is open to question whether the management of the pandemic and the notification of the existence of a risk should revolve around scientifically, should revolve around the risk of a trade or travel restriction. This is at least open to debate, in my view. So, I mean, the scientific nature of the decision can be questioned. If we then go through the criteria for recommendations, the criteria for the adoption of recommendations, well, again, one can see that there are elements which are clearly related to science. So again, the emergency committee, and then a risk assessment based on the circumstances of the case. But then again, the views of the states parties directly concerned are one of the criteria. So is this a political criterion, or is it just a procedural criterion? You need to hear the states, it makes sense. But, or shall you hear the state and consider their views in the determination related to the adoption of recommendations? So again, science is present in the process, but science is not the only factor at the basis of these determinations. What is of interest, and I come to the conclusion, I think, of my presentation, is that also the additional health measures which can be adopted by states, according to the international health regulations, well, should make reference or the determination based on the adoption of additional measure makes reference to scientific principles and to the available scientific evidence. So it is quite interesting. The international health regulations are from this point of view, they are exercising an indirect influence on state discretion. So states, they keep their prerogatives. They can still adopt additional health measures, but such measures shall be, of course, adopted in light of scientific principles and of the available scientific evidence. So, of course, and any available specific guidance or advice from the WHO. So, of course, the sovereignty of states in managing the pandemic is still present. Recommendations are not binding, but states are required to adopt their determinations in light of scientific principles, which is clearly stated in the form of an obligation with the verb shall in the international health regulations. So to conclude, there is no abstract incompatibility between the WHO legal framework and the protection of foreign investors. The WHO recommends generally the adoption of a risk-based approach and not of a precautionary approach, with due regard to scientific evidence and scientific principles. In case the incompatibility between the protection of the investment and the health regulations may derive from the adopted recommendations, so one should investigate the content of the recommendations. Decisions and acts adopted by the WHO, as I said, are based on the scientific method, but also other factors are relevant, so their scientific nature can be questioned. And the WHO legal regime implies the obligation to adopt a scientific method by states as well, also in the determination of measures adopted at the national level. So this is quite interesting, I think, for the repercussions these conclusions can have in the interpretation of the standards which were described yesterday, and also potentially of circumstances precluding wrongfulness. Thank you very much.
Thank you very much, Marco. You gave a very interesting reconstruction of the role of WHO documents and recommendations as regards also the decisions taken by states. Very, very interesting. I already learned a lot from these presentation, and I think that we will. I hope we have the time to discuss it afterwards. Now I like to ask Sondra Faccio to take the floor, and she will address, as I was saying before, namely some observations concerning whether and to what extent scientific knowledge and information have been employed by arbitrators in the assessment of states' regulatory measures. Sondra, the floor is yours.
Okay, thank you. So good morning, everybody. Thank you again for being here today. And thank you, Professor Nesi, for the kind introduction. My topic today will be scientific knowledge, and we'll try to discuss whether and to what extent scientific knowledge has been employed so far by investment arbitration tribunals to assess states' regulatory measures, and especially how, whether and to what extent scientific knowledge will be employed in the near future in relation to pandemic claims. So my presentation will be divided in 4 parts. In the first part, I will discuss some investment case law concerning cases so far using scientific knowledge to assess states' regulatory measures. I will provide a few examples. Then I will focus on some investment treaties, new generation investment agreements that express reference to scientific knowledge in relation to exercise the right to regulate of the states. And then a few new generation treaties which do not contain any reference to scientific knowledge, but nonetheless contain provisions on the right to regulate of states, and how this provision, how scientific knowledge may be relevant for the application of those provisions. We then discuss a little bit how and in what ways, in my opinion, scientific knowledge will be employed in the near future by arbitrators to assess states' regulatory measures, and some concluding remarks. There will be then time for questions and answers. So concerning case law so far, it's worth mentioning that scientific knowledge has been employed to assess whether the measure taken by the state was actually in good faith and for public purpose. Scientific knowledge has been referred to by arbitrators in the assessment of indirect expropriation to ascertain whether the measure adopted by the state was a legitimate regulation by the state or rather an indirect expropriation. The landmark case is Philip Morris, of course, against Uruguay. Here at stake were a couple of measures on tobacco controls. And the tribunal, based on the scientific data and reports presented by the WHO, which intervened as amicus curiae in this case, concluded that the measure adopted by Uruguay was actually in good faith for a legitimate public purpose, and therefore it didn't amount to a form of indirect expropriation. In particular, based on the evidence provided by the WHO and the scientific data, the arbitral tribunal stated that not only the measure were potentially effective means to protect public health, but they were actually capable of contributing to its achievement. Another interesting case, in my opinion, is the Olympic Entertainment versus Ukraine. Here the award is quite recent, is 15 April 2021. Here at stake was a gambling ban law adopted by Ukraine after 35 attempts to do that. Here the tribunal stated a sort of general principle. It said that whenever a state wants to adopt a measure for public health purposes, it would at least reasonably consider and discuss some of the evidence, and here the evidence is scientific evidence that measure adopted is actually effective or at least potentially effective for achieving the public health goal. In this specific case, the tribunal found out that the measure was actually aimed to address a public health goal and necessity. But nonetheless, even though it was in good faith and for a public purpose, it amounted nonetheless to an indirect expropriation because of its effect that were quite serious and disruptive upon the foreign investor, and because the state failed to offer the payment of any compensation. Scientific knowledge has also been referred to in the landmark case Metanex versus United States. Here, the question before the tribunal was whether science put at the basis of the methanol ban adopted by California government was actually a sound research or was merely a convenient excuse for the state to adopt the measure. The tribunal concluded in this case that the scientific knowledge put at the basis of the measure by California was actually based on a careful assessment of the problem, and thereafter the response provided by California with the ban was reasonably related to the research carried out, the scientific research carried out. And therefore, there was no indirect expropriation in the specific case. Scientific knowledge has also been used to assess states' measure in light of the fair and equitable treatment standard. Here again, the case Philip Morris versus Uruguay, where the tribunal stated expressly that the WHO Framework Convention Tobacco Control and related scientific research and reports was a point of reference on the basis of which to determine the reasonableness of the two measures and therefore assess them in light of the fair and equitable treatment standard. Concerning Crystal X versus Venezuela, here again, a general principle like the one concerning gambling ban and Ukraine, the tribunal said that in this case, Venezuela alleged to have undertook some permitted denial on the basis of environmental reasons. Here the tribunal stated that Venezuela in the specific case had the burden to elucidate the reasons for denying the permit, meaning to adopt a measure, with some kind of supporting data, scientific data concerning the environmental impact of the measure. In this specific case, the measures were, in the opinion of the tribunal, so fundamentally deficient to the eyes of a reasonable third person that they surprise a sense of juridical property, here quoting the Elsie case. So it was a violation actually of the fair and equitable treatment standard. All that to say that actually scientific knowledge so far has played a role in the assessment of states' regulatory measure, especially in relation to measure adopted for environmental purposes or public health. Here I'm now turning to investment treaties, and I picked this free trade agreement, actually three free trade agreements between EFTA countries and Ecuador, Georgia, and Philippines, because they all contain an interesting provision, in my opinion, that relates to the right to regulate of states and says that the state parties recognize the importance of taking account of scientific, technical, and other information and relevant international standards, guidelines, and recommendations when preparing and implementing measures related to the environment and labor condition, in this case, that affect trade and investment between them. Therefore, according to this provision, states to design and implement the measure in relation to environmental issues, they should actually take into account scientific information. Another FTA, in this case between China and Switzerland, contain very similar wording, stating that the parties recognize the importance, again, when preparing and implementing measures related to the environment, of taking account of scientific, technical, and other information and relevant international guidelines. These treaties that contain express reference to scientific knowledge are only a few, actually, but my point is that scientific knowledge may play a key role also in relation to the application of provisions contained in other new generation investment agreements, which do not contain specific reference to scientific knowledge, but nonetheless include provisions concerning the right to regulate. And I provide a few examples as to how those provisions can be applied and how scientific knowledge can be used to apply these provisions. Here, first example concerning Article 28 on expropriation contained the COMESA investment agreement, which contain a carve-out provision for with the right of states to regulate. This provision states that, consistent with the right of states to regulate and customary international principles on police powers, bona fide regulatory measures taken by a state that are designed and applied to protect and enhance legitimate public welfare objectives such as public health, safety, and environment shall not constitute an indirect expropriation. So my point is that states in the first place, but then also arbitrators that find themselves to decide over challenges to states measure brought by investors, that has to assess states measure in light of this provision to understand whether the regulatory measure adopted by the state for public health or environmental reasons is in bona fide. It should or it shall perhaps take into consideration whether the state made some research, scientific research, to assess whether there was in the first place an actual risk to the environment or public health, what was the magnitude of the risk, and what was the right response to the risk in accordance with the scientific data available. And that will be all an analysis that will help arbitrators to understand, as in previous case law, whether the measure is in bona fide, and also whether the measure is actually designed to face a public health risk. Without scientific data, how can the state prove that the measure was actually adopted to face a public health risk and also applied for that purpose? Another example, quite similar, is a provision contained in Annex 1 of the Burkina Faso-Canada BIT. Again, is a carve-out provision concerning expropriation. It said, paragraph 3 said that a non-discriminatory measure or series of measures of a party designed, again, and applied to protect legitimate public welfare objectives such as health, safety, and the environment does not constitute indirect expropriation, except in rare circumstances, such as when a measure or series of measures is so severe in light of its purpose that it cannot be reasonably considered as having been adopted and applied in good faith. So again, reference to good faith. I would like to discuss a third example, just because this example does not relate to indirect expropriation precisely, but to general exception. Here is still the Burkina Faso-Canada BIT, but Article 18, where again the agreement says that a state may adopt or enforce a measure necessary to protect human life or health, for example, provided that the measure is not applied in a manner that constitutes arbitrary or unjustified discrimination or a disguised restriction on investment. Here, the reference to disguised restriction recall expressly the Metanex case, where scientific knowledge was taken into account to verify whether the measure actually was a disguised restriction or not. So all that to say that scientific knowledge has actually played a limited role so far in investment arbitration, but is expected, in my opinion, to play a major role in the future. Scientific knowledge may, in the first place, confirm the existence of any environmental, health, or energy risk. It may also ground the response of the state to the risk. In addition, the focus shall be on the process followed by states to design and adopt the measures based on the scientific knowledge. This may ground the bona fide nature of the measure undertaken by the state, and also may help the state to justify the measure, arguing that the measure was not applied in a manner that is arbitrary or unjustified discrimination, because it's actually based on scientific information. I'm leading to my conclusion with a few remarks. If scientific knowledge is deemed to acquire a major role in investment arbitration, especially to ground states' regulatory measure, then there might be problems in relation to differences that may emerge between among countries that have different economic resources available for scientific research. And to face this type of problem, perhaps a nice solution could be that countries may use general standards and guidelines or scientific assessments, such as those provided by the WHO, for instance, or other NGOs. And in this regard, arbitrators shall be perhaps more open to allow amicus curiae intervention in proceedings in the case they are able to contribute with useful information to the tribunal in terms of scientific research. Another risk is concerning the role of arbitrators, that arbitrators shall avoid to decide over the truth or the validity of scientific data. Arbitrators are not equipped with the knowledge and capacity, in my opinion, to analyze the validity of scientific data, especially in case of scientific uncertainty, as the current situation we are actually experiencing. Rather, arbitrators shall focus on the production process of the scientific knowledge, and therefore they shall verify whether science is credible at the time it is relied upon by the state in undertaking the measure and in light of the production process, and whether the process of transforming the scientific knowledge into regulatory measure, is credible. And I thank you very much for your attention.
So thank you very much, Sondra. So Marco described the normative framework, while you were describing so to say, the battlefield, or what has happened and what could happen in the future. So you had some very interesting data on these, and also some very interesting thoughts. Gianmaria Farnelli now will focus on procedural matters and discuss the rules presiding the use of experts in investment arbitration. Gianmaria, the floor is yours.
Thank you, Professor Nerzi, and thanks to the organizer for inviting me to this event. Well, procedural issues pertaining to technical and scientific evidence in investment arbitration concerns the assessment of the legal framework governing the introduction of such knowledge in the proceedings. Such kind of knowledge may be the medical one, which may be required in assessing whether anti-pandemic measures, like the one were taken a couple of years ago, was unreasonable or disproportionate. The acquisition of such knowledge is commonly, if not exclusively, made through experts. Thus, my presentation will focus on the procedural side of the use of experts in investment arbitration. My presentation will come in two parts, next to this introduction and short concluding remarks. First, I will address three discrete issues concerning party-appointed experts, namely the filing of the report, the statement of qualification, and the basis of the expert report. Second, I will shortly address a few problematic issues concerning tribunal-appointed experts. Three preliminary remarks seem appropriate. First, the use of experts has become an ever-increasing part of international arbitration. Most, if not all, pleadings in investment arbitration over the last 15 years have been accompanied with extensive expert reports concerning mostly the quantification of damages. But legal experts too concerning domestic legal framework have been widely used, as the bulk of the recent ECT arbitration on renewable energies demonstrate. This trend is unlikely to be reversed. The potentiality for COVID-19 and climate change related litigation have been highlighted by many scholars also yesterday, and similar claims are likely to be heavily dependent on scientific consideration. Second preliminary remark, a technical or scientific expert report poses issues mostly concerning the assessment of its probative value. As Sondra was saying, this flows from the fact that similar reports rely on objective facts, defined best practice, research protocol, or industry standards, of which arbitrators are unlikely to be aware. These elements alone differentiate technical and scientific experts from other categories of experts, such as legal ones. That being said, the participation of technical and scientific experts in investment proceeding poses the same procedural issues as that of any other expert. From that standpoint, no distinction appears necessary. Third and last preliminary remark, the use of expert in investment proceeding is scantily regulated in rules of procedure. ICSID arbitration rules 35 only establishes that expert shall be examined by the parties and express the oath that the expert must take before testifying. Rule 36 simply confers the tribunal the power to admit written expert report. Ancestral arbitration rules are not more comprehensive. Article 17 simply refers to the possibility to present, and I quote, evidence by witnesses, including expert witnesses, end of quote. Article 29 regulates tribunal-appointed experts, allowing any party to object to the expert qualification, impartiality, or independence, and the right to examine him or her. As it is apparent, such rules, which inter alia equate experts to witnesses, are far from detailed. Thus, tribunals in their practice have been compelled to complement the scant regulatory framework. Arbitrators have done so by using their inherent power to conduct proceedings as they consider necessary for the appropriate administration of justice. Such power can be inferred inter alia from Article 44 of the ICSID Convention and Article 17 of the Untitled Arbitration Rule. Well, in particular, I will show that tribunals have exercised such power by following soft law rules elaborated by professional associations. In the interest of time, I will exclusively refer to the International Bar Association rule on the taking of evidence in international arbitration, which are the most commonly referred to in the matter. In particular, I will address Articles 5 and 6, respectively, on party-appointed and tribunal-appointed experts. However, the IBA is not the only association who has produced procedural soft law. For example, the Chartered Institute of Arbitrators has adopted in 2007 a protocol on the use of party-appointed expert witnesses in international arbitration. I will now address the first procedural issue concerning party-appointed experts, namely the filing of the report. According to Article 5 of the IBA rule, the report is to be filed within a time frame set by the tribunal. Such guideline is generally followed by investor state tribunals to the effect of requiring expert reports to be filed at the earliest possible stage of the proceedings. This is exemplified by procedural orders in the ICSID case, Gabriel Resources versus Romania, and in the ancestral case, Lone Pine versus Canada. The IBA rules are silent on the consequences of late filings of expert reports. The arbitral practice has filled this gap by sanctioning such procedural misconduct with inadmissibility. For example, procedural order number 1 in Spence International Investment versus Costa Rica provides that, and I quote, the tribunal shall not admit, and shall is a strong word, any expert testimony that has not been filed with the written submission. It is to be noted that investor state tribunals, arbitration, differs from general international adjudication with regard to the consequence of late filing. As exemplified by Article 56 of the ICJ Rules of Procedure, the adjudicative body usually maintains the power to allow late production of evidence of whatever kind, including expert report, even with the disagreement of the other party, if it considers that evidence necessary. The point may be made that this practice by investment tribunal flows from consideration of judicial economy, which, as most of ECT cases demonstrate, is always in the forefront of arbitrators. Article 5 of the IBA rules also requires that the report include, and I quote, a description of the expert background, qualification, training, and experience, end of quote. Investor state arbitral practice conforms to such guideline again. For instance, procedural order number 1 in the ancestral case Resolute Forest versus Canada provides that, and I quote again, each expert report shall include a statement of qualification of the expert in the claimed area of expertise, end of quote. Similar language may be found also in relevant ICSID tribunal orders, such as procedural order number 1 in Menzies Middle East and Africa versus Senegal. The IBA rule again are silent on consequences of incomplete filing of this information. Arbitral practice suggests that matters concerning the expert's qualification and expertise are evaluated with regard to his or her credibility. That means that rather than impinging on the admissibility of the report, this impact on the weighting of its probative value. The UCOS arbitration is a good example to that fact. There, the tribunal allowed the production of an expert report by a non-lawyer on the termination of the ECT. The tribunal, after the cross-examination by the claimant, concluded that the report was not authoritative. The practice of not meeting lack of qualification of expertise with inadmissibility arguably flows from the consideration that arbitrators lack the competence by themselves to assess such element as early as the filing of the report. This is particularly the case with regard to technical and scientific expertise, which the arbitrators would most likely be unable to assess due to the sectorial nature of such knowledges. While the decision to allow the production of a report and let the tribunal assess its probative value may appear a sensible one, it is to be noted that such production implies that the other party will have to produce evidence to counter it. This applies also in the case of expert report drafted by unqualified persons, such as the UCOS arbitration demonstrate. This obviously implies costs, which arguably should be avoided in the interest of judicial economy. It is arguable that the assistance of a tribunal-appointed expert, in particular a scientific one, from early stage of proceedings might be instrumental in avoiding such costs. The expert might provide her or his expertise also on the qualification of the party-appointed expert, thus allowing the tribunal to assess the relevance of the report and then decide whether to admit its production or not as an eventual irrelevant evidence. The third and last requirement of the expert report under the IBA rules is the inclusion of a statement of facts on which the expert is basing his or her opinion. These include the indication of all the documents on which the expert relies. As it is apparent, the rationale of such requirement is assuring the counterparty a fair chance to challenging the substance of the expert opinion. Arbitral practice generally adopt an identical requirement. One may recall as examples to that effect procedural orders number 1 in BSG Resources versus Guinea or South American Silver Ltd versus Bolivia. The latter case is of particular interest due to the extensive interpretation of this requirement by the tribunal. The respondent Bolivia asked for the production of a transcription of certain unwritten notes taken by the claimant's expert while talking to analysts in order to prepare the expert report. The claimant objected that such request had no basis in the tribunal procedural order number 1. The tribunal found for respondent, holding that, and I quote, "The conversation between the expert and these 4 analysts are information upon which the expert report relies." Well, the tribunal was assisted in reaching this conclusion by the introduction of the report itself, which hinted to the relevance of such note. However, a situation of uncertainty are far from rare, and neither the IBA rules nor the case law provide clear guidance on the issue. Against this background, it appears sensible to agree with those who argue that the relevant criterion should be whether the information in point introduces non-fact. This is arguably particularly relevant for scientific expert report, which for their very nature may introduce a number of new facts in the proceedings. I come to the second part of my speech on tribunal appointed experts. Article 6 of the IBA rules codify the inherent power of tribunal to avail itself of experts. The guidelines enclosed in such provision mirrors mutatis mutandis, those laid down for party-appointed experts. Thus, a tribunal appointed expert has to provide a statement of its qualification, a written report, and indication of facts and information on which the report is based. Arbitral practice concerning tribunal appointed experts is way minor than the one on party appointed experts. Needless to say, it is highly unlikely that the submission of a tribunal appointed expert presents irregularities to the point of being inadmissible. That being said, 2 issues are to be recalled. First, the tribunal appointed expert report has to be provided to the parties, and the expert may be examined by counsel and experts of both parties. This put the tribunal expert on an equal footing with respect to party-appointed experts, in compliance with the equality of all principle and the adversarial nature of investment arbitration. Second, the independence of a tribunal appointed expert is more sensitive than the one on a party-appointed expert. As the Abelkarat case show, relationship between a tribunal appointed expert and one of the parties may be raised as a ground for disqualification of the expert, similar to what happens with regard to arbitrators. Furthermore, the ad hoc committee in ExxonMobil acknowledged that a lack of impartiality of the tribunal appointed expert may impact on the tribunal's impartiality, though not automatically. This may obviously ground an application for annulment. Well, summarizing my argument and concluding, the gap in the procedural system concerning the use of experts in investment arbitration has been indirectly filled by professional associations such as the IBA, which have elaborated their own guidelines in the matter in point. Such guidelines have been consistently followed by investment tribunals. This has assured consistency in arbitral practice, thus increasing its legitimacy. However, direct regulation by relevant ISDS institutions, such as the ICSID, appears advisable. This flows from the obvious consideration that scientific expertise, in particular, will become more and more relevant in investment arbitration, given the potentialities for COVID-19 and climate change-related investment litigation. Unfortunately, ISDS institutions do not appear to be willing to take steps in that direction. Proposal for amendments of Rules 38 and 39 of the ICSID arbitration rule, at least as drafted in the latest working paper of June 2021, are still silent on most of the procedural matters surrounding experts. This compels tribunal to keep on filling the relevant procedural gaps. They would probably do so by keep on following professional association guidelines to the effect of turning their procedural soft law to some sort of jurisprudential normative authority made through procedural orders. This concludes my presentation, and I thank you for your attention.
Thank you. Thank you very much, Gian Maria. It was also, this presentation was extremely interesting, and also it contributed somehow to enlighten the complexities and also the gaps of a very delicate phase of possible investment arbitration. So thank you again. I think that there will be a lot to be debated, and but before doing this, I think that we have to give the floor to our discussants. First of all, I will invite Professor Eric de Brabander to intervene. Eric, the floor is yours.
Thank you very much, Professor Nesi. Thanks also to Marco and Nino for having invited me to present some remarks on these presentations. Thanks also for accommodating the hybridity of this workshop seminar. So many thanks. So first of all, I find the presentations really very interesting. They're all very complementary also. So while Marco, I think, focused a bit more on the existing regulations and the impact use of these regulations in possible future cases, but also in national legislation, which I find quite interesting, because in the end, these national legislations might also be used in investment arbitrations. So, and then I also much enjoyed Sondra and Gian Maria's presentations on what is already done, what has been done in terms of engagement with scientific evidence in investment arbitration, both substantively and then procedurally. So what I'll propose to do is, in a couple of minutes, offer maybe some scattered remarks on the role generally of scientific evidence. I also see some interesting connections with what was said yesterday in the discussion, of course, on the precise standards of treatment that might be used to accommodate claims of investors who feel to have been in the subject of damage by the regulations. I think the idea to focus first on substance and then on procedure is quite interesting and important to keep the distinction between the two. I want to generally wonder what the role of scientific evidence is. And here I want to also draw a parallel, not only on the specific field of investment arbitration, but also on what has been done in other fields of dispute settlement, notably in the International Court of Justice, which I find quite interesting. I think the whole idea of scientific evidence or scientific experts has probably legally an importance, but also as a term in terms of what I would call argumentative authority in proceedings. So the first point, of course, is that scientific evidence, especially what Marco explained, the regulations, the existing regulations, how they have been used in practice to justify certain decisions, is of course fundamental, because the first aspect area where you see the relevance of scientific evidence also in other proceedings is, of course, to either establish a breach of a norm, establish the existence of a circumstance precluding wrongfulness, or an exception. Right? And you see it very much also in the International Court of Justice in the cases where scientific evidence was actually quite important, the whaling case and also the pulp mills case, where you see that it was justified mostly in the pulp mills case to establish a breach or not, and in the whaling also but a bit more complex. So this is, of course, very important. First of all, can we establish? And I think the science as such has a sort of neutralization or internationalization or externalization effect. That is, states will say, I did not decide this. This was the World Health Organization. So we merely follow the international recommendations. And as a consequence, we can objectivize our position, right? So it's not our subjective act that resulted in a loss for the investor, but it's basically us implementing what has been decided on the international level. So this is an important aspect. I think it also ties in with standards of reasonableness and due diligence that were discussed yesterday also by Julian, also in reply to a question of Marco, if I remember well, on the reasonableness. This objectivization, if I can say, it's not a good word, but I mean, it sort of removes a bit the idea that the state for itself decides what is its regulatory space, right? It's basically the regulatory space is defined by reference to what is already out there, to what is decided by others. And this, of course, ties in with the scientific nature of the World Health Organization, notably. And I see here also links which have been clearly discussed by Sandra with the tobacco plain packaging cases, right? Where there was a heavy reliance on the positions of notably the World Health Organization, the Pan-American Health Organization, which I think are quite interesting and show a lot of parallels with potential cases that might come and that probably will come in the near future. So that's this objectivization is in terms of substance quite interesting. Again, I think it sort of gives content to reasonableness and to the regulatory space, but it's also probably an easy way out for states confronted to claims of foreign investors by again arguing that their decision was influenced by what was decided on the international level. And this brings me to my second point, is how do tribunals, or how can they actually engage with scientific evidence? The interesting thing, and I take here also research that has been done by two colleagues who you also know, Jean d'Aspremont and Makan Mbenge, who have written on scientific evidence before international courts and tribunals more generally. And I side with their argument that scientific evidence lies a bit in between law finding and fact finding. So law finding, as you know, and also Attila Tanzi, if he's still there, I can't see him working on Jura Novit Curia, is the main idea, of course, that the judges, the arbitrators know the law, they apply the law, they discover the law, they apply it to the facts, right? This is an exercise that is less based on establishing the objective veracity of what happened, right? It's really, this is the fact component. Facts are or are not present, and they are established or not by the court or tribunal. The law is a bit more relating, or a bit more, I would say, less binary, in the sense that you have facts, this happened or this has not happened. So it creates an appreciation by the court tribunal of what the law is, what the exceptions are, etc. So this, of course, is inherent in the judicial and arbitral function. Scientific evidence is sort of in between, right? It has some elements of fact finding because it is also to a certain extent linked to the existence or not of a certain truth, right? We have a pandemic, we don't have a pandemic, but it has also an element of probability, which you find that is similar to law finding and law application, right? As with lawyers, we can differ on the existence of norms, the exceptions of norms, and scientific experts have relatively similar, not identical, but relatively similar, are in a relatively similar position, right? There's a lot of discussion, of course, on the objectivity of science and scientific evidence. And this creates, I think, a sort of hybrid of scientific evidence compared to what the traditional role of a tribunal would be: law finding and fact finding, right? Science is a bit in between, right? It's between certainty and probability. And this makes it a very tricky exercise. And it also, I think, justifies or explains why there's still a bit uncertainty on how to best engage with this. Right? And here I think I will come to the idea that use of scientific evidence is really a question of argumentative practice before courts and tribunals. And this very much relates to what Gian Maria has explained on the use of experts. I do think that you can't completely equate scientific experts with other types of experts in arbitral proceedings, precisely because I explained that I think scientific evidence is really not either factual evidence or legal evidence. Right? You have legal experts, they basically inform the tribunal, who then decides based on the expert opinion whether the tribunal agrees or not. Right? Fact finding is a bit more difficult. If there are fact witnesses who establish that this happened, it's a bit difficult for the tribunal to say, no, we disagree, it didn't happen. Right? It's a bit more binary. And then again, scientific experts come a bit in between. Right? So they offer their scientific evidence. And the tribunals, you see, the examples was also mentioned of UCOS, amongst others, you see it very much also in damage calculation. Tribunals still keep a huge discretionary approach to scientific evidence, right? Especially if it's used by the parties. It's more accepted that if the tribunal appoints itself a scientific expert, it's slightly more bound, you could say, or is likely to follow what that expert has said. But if it's party-induced or produced evidence, tribunals, very much similar to legal experts, can also simply disregard or disagree in light of conflicting scientific evidence. So the strategy of engagement with scientific evidence is something that will be tested, I think, with the cases that will come. And I think I don't offer any solutions, to be honest. I just think it's something that we will see evolve quite importantly in the years to come. For now, you don't have so many cases. I think, again, the plain tobacco packaging case are closest to what we now have. But there are only two cases, right? One that didn't even make it past jurisdiction, so there's really only one case. So I'm curious to see how arbitrators would deal with scientific evidence and the existence or not of a shared opinion on this is what should have been done or not. I think we should treat really the scientific evidence as more a hybrid between law and facts, and not as either law or as facts. It's something that lies in between. So I'll conclude here my remarks, and thanks again for the three presentations. I find them very interesting and also very complementary. So I think it makes a very good general approach to scientific evidence in this field. So many thanks, Pepe.
Thank you very much, Eric. Yes, I thank you for these very interesting observations that reminded me about my first difficulties with when I started studying law, even before studying international law. So the necessity of taking into account law and facts and the relationship between law and facts. The issue of the antagonism between certainty and probability, and as regards the arbitration, or I say more broadly, judicial and arbitral functions, the role of scientific and other experts. And I thank you also for recalling some ICJ cases where scientific knowledge was taken into account. I forgot also to say that Eric has been also visiting professor at the University of Trento, and we are very proud of having had him here some years ago, and we hope that he will come back, of course, one day. Pia, the floor is yours. Professor Pia Conci, I already introduced Pia, professor at the University of Trento, International Economic Law, and the author of many. Teramo. What did I say?
Trento. Wow.
You know, there is a sort of twinship. So this is why
I mix up.
I cannot
It's not
make
only the problem
we are
of the starting, of the starting letter.
Okay,
but,
thank you.
I thank you again, Pia, for being here, and I invite her to comment.
Okay, thank you very much, Pepe. And thank you very much, all the speakers, for the excellent and interesting presentations. Of course, I would also like to thank the organizers for inviting me as a discussant. What I really liked about the presentations is that they made an appropriate sequence one after the other. I would like to make a few comments. I start from a few general comments, and then I will make a few specific comments, and they will not be questions, but I would say a few suggestions for your further research activities and for hopefully exchange of views in the future. So, starting from general comments, we are discussing the impact of the COVID-19 pandemic on investment in a disrupted economic context. I think we have to remember that the pandemic came after a decade of difficulties, economic, financial difficulties because of the 2008 financial crisis. I think that is important to remember. The COVID-19 emergency has been a regulatory risk from the perspective of international investment law. We have discussed this to a large extent since yesterday. The COVID-19 emergency has been considered so far an unprecedented situation. Of course, we have global health at risk, global economy at risk, economic advanced states have been in difficulties, hard difficulties, as usually developing countries are. But I believe that this emergency is was also a likely situation due to previous warnings from the World Health Organization, sometimes in collaboration with other UN international organizations such as the World Bank. I have other times said that we have a report from the World Health Organization together with the World Bank that was published in 2019. So a few months before the pandemic, let's say. And in this report, these two organizations set targets for any state, any member state, in order to be ready to face a risk, a global health risk, such as the COVID-19 pandemic. And this report is called A World at Risk. And these targets were supposed to be achieved in a year, so in a very short period of time. So the report was published in September 2019, and these targets were supposed to be achieved by September 2020, but the pandemic came before, in between. So I don't share, on the other hand, the view that the World Health World Health Organization leadership is so undeniable, because since the 2014 Ebola pandemic in West Africa, I think the World Health Organization leadership, its authority as its constitution states, has been a matter of discussion, not only because of possible failures within this organization, but also because a sort of distrust from other organizations within the UN system. Sometimes the World Health Organization position has been diluted within international partnerships, international multi-actors actions for development assistance or for health risks. But if cases arise from anti-COVID domestic regulatory measures, we have discussed that a host state that took this kind of measures might rely on its police powers as a regulatory authority to justify possible detrimental implications for foreign investors. But we already understood that probably this counterclaim based on police powers might not be so well grounded. And I would say that possible counterclaims based on international treaties on human rights, including the right to health, might also not be so good to justify these regulatory measures. I would say that possibly states might rely on the fact that a number of these domestic regulatory measures included financial assistance, financial support for companies, not only for citizens, I mean affected citizens and affected companies from the closure of non-economic essential activities and so on. So these financial assistance remedies were used by companies, for example, to pay wages during the emergency, at least the first waves of the pandemic. So possibly states might try to avoid the payment of compensation in accordance with international investment treaties that would be higher than the financial assistance included in their domestic laws, by saying that they did what they could do. But we don't know, we have to see. On the other hand, a foreign investor relying on the applicable international investment treaty, yes, could be able to bring a claim by referring to a couple of possible points. Possibly, one point might be that the affected states could have contributed to the emergency by not taking into due consideration not only warnings coming from international organizations within the UN system, such as that report in 2019, but other reports, warnings that were published between the Ebola pandemic and the COVID-19 pandemic. We cannot, I mean, we cannot deny that states lack the capacity to detect and deal with this virus. No early warning capacity, no treatments, no vaccines. So there was unpreparedness also from the pharmaceutical companies, not only from states. I mean, none of these actors had invested in this field. So we had inadequate measures. A few scholars, experts already said an epic failure, unfortunately. And there are cases, such as a few cases, the Azurix versus Argentina case, that already dealt with this matter by saying something about a possible balance between a host state's police power and its alleged contribution to a public health emergency. So for a state, there are possible justifications, but this point, I believe, from a foreign investor might be quite strong. Another strong point might be that the states didn't fully fulfill their obligations under the international health regulations. They incapacity somehow to respond to prevent further spread of the virus during the first wave and the second, the third, would be different if they had fulfill the international health regulations. And the international health regulations are mandatory, are not recommendations. They are mandatory according to the World Health Organization Constitution. Then there is also that possibility that foreign investor might rely on the fact that states didn't take recommendations into due consideration. So going to my specific comments for Marco first. I would say that legal diversification typical of international law could jeopardize the importation into international legal framework on investment of relevant rules adopted by international organizations such as the World Health Organization, if the applicable international investment agreement would not allow this kind of regulatory operation, I mean the importation. The Philip Morris case, yes, is a significant case, but in that case, the domestic regulatory measure was based on the Framework Convention on Tobacco Control, was an implementing measure of that Framework Convention. When we think about these anti-COVID regulatory measures, I believe that we cannot say that these measures have been implementing measures of an international treaty or the international health regulations that are binding, because the international health regulations were published and adopted in 2005 and into force in 2007. And in effect, as you said, Marco, these regulatory measures don't mention the international health regulations. So because they are not implementing this kind of piece of international rule. So I would say that here we have a problem, I mean, in matching the two different regulatory words. Going to the presentations from Professor Farnelli and Faccio, okay, I understand that after the COVID-19 pandemic, we might agree that the legitimacy and reasonableness of a host state's measure or the decision not to take measures in response to a pandemic might be scrutinized on the basis of scientific knowledge and scientific uncertainty, as Professor de Brabander pointed out. But how science was used during the pandemic, and specifically what science? I mean, we have seen digital tools were used at large, so there have been a combination between digital tools and science, scientific knowledge. Digital tools were used to analyze the data and integrate scientific data, for instance, in relation to epidemiology. And there has been an increasing relevance of artificial intelligence, particularly of algorithms, to analyze this scientific data. So I agree with Professor that how objective, we might wonder, how objective is the scientific knowledge? And what points of conceptualization of scientific knowledge we might take into consideration? What kind of scientific knowledge and data, given the variety of scientific opinions, and we have seen and we see every day discontent, distrust, public distrust towards scientific knowledge. So, as far as my opinion is concerned, I believe that open science, open data, open innovation, of course, would be necessary to enhance both the response capacity to epidemic from states and the transparency of possible treaty-based arbitral proceedings. For the sake of clarity, I believe that further revisions of applicable international investment agreements are needed. Without this kind of regulatory operation, I mean, further revision of these treaties, consistency and coherence of arbitral proceedings might become more controversial. We have already experienced this. I mean, over the last 20 years, because of the complexity of cases based on the competing interest, economic and non-economic interest, and the lack of relevant provisions in international investment agreements, there had been a shift I would say, from dominance of party-submitted evidence to broad discretionary powers of arbitrators. So if states and international organizations don't clarify how scientific knowledge and data might be a reference point, possible cases would become more complex and the discretionary powers of arbitrators would expand, but arbitrators would be under pressure once again, and even more possibly. So I think that possibly, and this is my last remark, this situation and given scientific uncertainty might bring states, international organizations to try to an innovative approach towards a multilateral approach in treaty design. That is one of my old issues, research topic. And the COVID-19 emergency has revitalized, at least for a while, multilateralism through international organizations for the purpose of avoiding the fallout of the world economy. So multilateralism might be an approach to accommodate these uncertainties and the politicization of the international investment climate in order to accommodate different interests at stake and having a favorable climate for foreign investments. Thank you very much.
Thank you. Thank you, Pia. So if possible, now things are even more complicated, I would say, so because Pia also was wondering whether what would have happened if states observed the WHO international health regulations before, of course, the pandemic, how science was used during the pandemic, how objective, maybe one could say how scientific is the scientific knowledge. So maybe there are further burdens on arbitrators, although at least Pia suggested that multilateralism can be the way out, maybe, but we have to think about. Now, I think that we can invite our speakers to reply to the comments. So I start again with Marco. Marcus, please.
Okay, so perhaps starting with the comments by Professor Acconci. Thank you very much. Of course, on the leadership role, that was a wrong phrase. I started by writing a leadership role, and then I questioned my own phrase, in the sense that it is quite clear that to a large extent recommendations are not implemented. The obligations related to preparedness are not implemented, are not respected in several cases. But the fact remains, this is the multilateral institutions adopting quantitatively a body of documents, a body of, to some extent, norms, which has become the point of reference. So states are using the WHO as a point of reference, of course, also very often to criticize the WHO, but it is the point of reference of the debate. Also, when the debate is about substituting, replacing the WHO with another institution. So, but I'm with you. I agree. A leadership role in the sense of shaping behavior by states is this is not the case. Nonetheless, these documents are available, they are present, they are widely commented upon. So the question whether they can be used before international arbitrations is an actual question, is a question which can be asked. In my view, it can be relevant. That brings about the question of what they are, these documents. What are they? Are they providing scientific knowledge? Can we call them scientific in nature, and my point during the presentation was that they are not entirely scientific, because they make reference to scientific principles, they make reference to scientific evidence, but also other factors are relevant in the decision-making process. So that was my point. They should not, in my view, treated per se as documents providing scientific knowledge, because the decision-making process is a little bit more complex. Of course, I didn't mention Philip Morris. You're right. The guidelines quoted in the amicus curiae are guidelines which are adopted implementing the framework convention. So I think it is a different case in this respect, because in that case there is a convention and there are guidelines adopted implementing the convention. So they will probably be put to a different use. That kind of guidelines, and perhaps my final point is it is true that states can adopt additional measures. They are allowed to adopt additional measures, of course. That was an object of debate at the moment of the reform of the international health regulations, but at the same time they need to show that they took into account scientific principles, available scientific evidence, and also any available specific guidance or advice from the WHO. So when they exercise, public authorities exercise their discretion, they need to show, according to the international health regulations, and you reminded us that they are binding, of course, in binding obligations, they need to show they took into account advice by the WHO. So I was another part of my paper, which I did not tackle today, was about the question I posed yesterday. Does it make a difference when there is a binding obligation? Does it make a difference when we can construe these documents as being binding or as implementing binding obligations? And the tentative answer, which I did not mention earlier on, the tentative answer is, in my view, at least when it comes to legitimate expectations of the investor, this can make a difference, because the investor may claim, in my view, that the state had a duty to a legal obligation to implement the core obligations related to preparedness, related, of course, to the implementation of the international health regulations. So I think an investor can legitimately expect a state to abide by the rules, and the rules are clear. So there are of course obligations which have not been implemented, as you said, but they are still obligations. So perhaps at least an impact on the legitimate expectations can be argued. So that was my tentative answer with respect to the binding nature of course the norms originating from the international health regulations. With respect to the comments by Professor de Brabander, I mean, I share them, and they are food for thought. So I will look into them, and of course, this presentation was also about trying and see whether these documents adopted by the organization are scientific in nature, or whether they are something in between. And this is to some extent connected to the distinction between law finding and fact finding, which was in my view a very interesting point made by Eric. So thank you very much.
Thank you, Sondra.
Yes, thank you for comments, Professor de Brabander and Professor Acconci. I was very fascinated by the objectivization effect mentioned by Professor de Brabander, which somehow give content, if I'm quoting, to the regulatory space of states. At the same time, I was also referring, this concept refer also to the question of Professor Acconci concerning objective deviation effect, but how objective is the science relied upon by states, especially in these times of great uncertainty with very different opinion concerning scientific data and response to the pandemic. And that I think is actually a problem, but that I can't recall the case, but there's a case where arbitrator said that this cannot excuse an arbitrator from taking in any case a decision based on the scientific information provided by the parties or gathered by the arbitrators themselves with their own experts. What I think it matters is the method, whether the state can show that he followed a method which is followed due process, is somehow reasonable in gathering scientific data from different sources and analyzing that, and then provide a response to the health risk based on this scientific data it collected without indulging into assessing whether the data themselves are valid, because actually we are in a time of uncertainty. So we have arbitrators and states in the first place should try to adopt due process in gathering the scientific data, and that may avoid the judging concerning the validity. I would just like to add a few notes on that, because yesterday, and I'm quoting, I think, Professor Levashova, discussing the application of the fair equitable treatment standard, said that the measure shall be justified by the state through records and evidence. So I think that the state is able to provide records that he followed an orderly method and process in gathering the scientific information. Then, based on the information, he designed a regulatory measure that could be the way to resolve the problem of scientific uncertainty and the lack of objectiveness. Thank you.
Thank you, Sondra. Gianmaria, I see that now it's 11 o'clock. We will have, I hope, after Gianmaria, a short Q&A, if possible, but we should try also to be almost on time. But Gianmaria, please.
Okay, so thanks, Professor De Brabander and Professor Acconci, for your very useful comments. Will certainly help me improve my analysis for the paper. Just to to be short, given the time constraint. Oh, right. The habit. I share Professor De Brabander and Professor D'Aspremont and Professor Mbengue view on the, let's say, a non-binary nature of scientific knowledge, scientific evidence in international proceedings, also because, well, science tries to explain how things works rather than expressing whether a fact exists or not. But I think that this relates to the probative value of a scientific evidence rather than the way in which that evidence is introduced in the proceedings. This is my first reaction, but I have to further consider it. And with regard to the last comment by Professor Acconci, I totally agree that open data, well, open access to scientific knowledge, let's say, would enhance transparency and the legitimacy of investment arbitration whenever, let's say, scientific knowledge enters it. But I'm not sure that an arbitrator would use the typical instrument for acquiring public data, so judicial notice, to access to scientific knowledge, because I think that it would, well, on the one hand, enter a field is not very competent, and on the other, attract some, let's say, some criticism by, in particular, investors. But that's a really interesting issue. So thank you.
Thank you. Thank you very much also for keeping it very short. Thank you, Gianmaria. So now we are in our timetable, there is a Q&A. So yes, first of all, I give the floor to Professor Andrea Gattini.
Thank you very much, Giuseppe. I have two short questions, so one to Sondra and the other one to Gianmaria. More than question, they are just curiosity. So Sondra, I was a little bit puzzled by the choice you made of the bilateral investment treaties. So examples of taking into consideration of scientific knowledge about health matters in the new generation of free trade and investment protection treaties. You choose, I don't know if you did on purpose, treaties by the EFTA and not treaties by the European Union. And so I wonder if European Union is lagging behind in this because it has been so much defeated in the hormones case and the WTO that they do not, they prefer not to tackle phase on this matter of health measures, on health protection measures, so that was my question. For Gianmaria, the question is, you mentioned Article 36 of the ICSID rules, which is very short and reminds one to Article 50 of the ICJ statute. And I think it is not by chance that the two articles are kept on very short and very vague terms. That means the tribunal, as the ICJ, may appoint experts. And Eric said, it's not by chance because the tribunal, as the ICJ, wants to keep broadest discretion on this matter. But the point is, as Eric said, that after having appointed the expert, the tribunal or the ICJ loses much of its discretion, is having a sort of elephant in the deliberation room. So what to do with the expert reports which have been asked expressly by the court. So I was puzzled. My curiosity is if there are examples of expert phantoms also in investment tribunals, jurisprudence, because as you know, the ICJ was much criticized for doing that by semi-Alcazone individual opinions in the Pulp Mills case. And after that, the ICJ by now is more cautious about this. But I wonder if, well, you know, in the case of Uganda against the Democratic Republic of Congo, Uganda councils just demolished the expert opinions or the expert appointed by the court itself. So now the court, I don't know. Well, I'm not so impartial because I am on the side of Uganda in this case about the evaluation of war damages caused by Uganda in the DCR. But the point is that the ICJ now will have a huge problem in overcoming the criticism, which was really clear and open criticism, and I think well-founded criticism of Uganda. So my curiosity was, what about expert phantoms in the international tribunals? Thank you.
Thank you. Thank you very much, Andrea. Any other question? Professor Collins?
Just a very quick question, following up on some of Eric's comments, which I found interesting. Is it so much a question of establishing the fact and the uncertainty of the facts, or is it really about managing risk and an approach to risk? And in that regard, I wonder if anyone on the panel has any views about the precautionary principle, which many people consider to be anti-science.
Thank you very much also for this question. Any other? Elena Fasoli, Professor Fasoli.
Thank you so much. Sondra, I have a question for you. Since you investigated practice, I was wondering, is there the reference to the principle of proportionality mentioned, for example, when there is this reference as to the regulatory measures to be balanced against the protection of health and the environment? Because in the environmental context, the principle of proportionality, which is also an international principle, comes into the picture many times. I'm just thinking about restriction of trade in the European Union legal system, for example. It is every time mentioned as to a reference to the need to balancing of the interests in this sense. So I was wondering, that you have investigated the practice, is it also there? Or does it come into the picture ever? Maybe not, maybe yes. I have no idea. Thank you.
Thank you, Elena. If there are no other questions, I would ask our panelists to answer. So Sondra will start.
I'll go first. So thank you all for the questions. I will start from Professor Gattini. Mine is a work in progress, honestly. I'm still exploring whether there are other agreements that contain such provisions. I focused on the EFTA because I found it interesting. It was the only so far agreement together with China, Switzerland, FTA, and I repeat our FTA, and now I have the opportunity also to add something on my presentation on that aspect, that expressly refer to scientific knowledge in relation to the exercise of regulatory powers. So far, I've carried out some research also on EU agreements, but I haven't found an express reference in those terms, guidelines, scientific knowledge, and principles, etc., as the two provisions that I illustrated today. Honestly, this is to my best knowledge, and at this time, because more research has to be performed on this topic on my side, even because we are, as you know, planning to write papers on that for creating a book. What I want to add is that those provisions are contained in FTA, which only provide a few provisions on investments and actually not regulatory, not the classical provisions contained BAT, but just a few provisions concerning regulation and opening up to investments, and then refer to previous or further agreements to be concluded on investments. What is, for instance, interesting, in my opinion, is that Switzerland, China FTA that I mentioned, which include this provision on the use of scientific knowledge, between Switzerland and China, it exists a previous BAT, which is an old generation one with no provision on regulatory space for states, but the traditional indirect expropriation provisions, FET standard, etc. I think that in light of Article 31.3c of the Vienna Convention, the subsequent FTA, which expressly contain reference to scientific knowledge in the exercise of regulatory powers, may be helpful for applying and interpreting the provisions of the old generation BAT between the states. Concerning the precautionary principle, I just would like to spend a few words. There are sometimes a sparse reference to that in the scholarly debate concerning the use of scientific knowledge in investment arbitration. This will be for sure one defense ground by states, in my opinion, in investment arbitration. And let's see what arbitrators will say concerning that. And then the question by Professor Fasoli as to the reference of principle of proportionality in concerning regulatory measures. Yes, it's a pillar, one of the pillars of at least one of the theory, for instance, concerning the detection of indirect expropriation and in relation and comparing to the exercise of regulatory powers. So the proportionality between the measure and the purpose pursued by the state and the effects produced by the measure itself, for instance, has been taken into consideration not only in investment agreements, new generation investment agreements, but also by many arbitrators in interpreting all generation BATs and investment agreements, and will probably play a role also in future investment arbitration concerning the pandemic measures. Thank you.
Marco Gianmaria.
So just a short answer to Professor Gattini, and thank for the question. To my best knowledge, there's no practice of expert factum in investment arbitration, or at least, well, if a practice exists, it has not been criticized as it has been done before the ICJ, but I will surely look further into it just to complement my paper. Thank you.
Thank you. Yes, the questions are also good hints to go further. So thank you again for the questions. Marco?
Very quickly, the approach by the WHO seems to be a risk-based approach based on the circumstances of the case and in the light of scientific principles. So it is not a precautionary principle approach, which seems to be adopted at times by states with these sweeping measures. Related to that, the problem is, I mean, one can read an element of proportionality also, considering that proportionality in the three-step proportionality, first of all, is efficiency related to a purpose, and efficiency related to a purpose perhaps requires a scientific analysis of such efficiency. What is interesting is that the purpose is not only health related, but the purpose is also related to avoid unnecessary restrictions of trade and travel. So the purpose is not entirely health related. There is a balance of purposes in assessing the proportionality of the measure. So this is what comes to my mind based on proportionality and precaution.
Thank you, Marco. I don't know whether there is any other questions or whether Eric or Pia want to intervene. If this is not the case, I would say that we have just to thank our panelists and the discussants. The presentations were really very, very interesting, and I would say that the final result, the outcome of this panel will be in a written form, hopefully, and it will form an important part of our consideration. So thank you again. Now I think that I have just to step down and to give the floor to Reza Eftekar, who is we will present the okay. So I can immediately ask Eric to take take the floor and to be the chair of these further part of the colloquium, and I will stop here. So I spoke even too much. Thank you very much again, and all the best for this initiative. Thank you.
Thank you very much, Pepe. I'll officially take over chairing for this last part of the seminar. So I'm very happy to welcome both Reza Eftekar and Filippo Fontanelli to discuss what is in fact the 20th volume of our book series, the Nijhoff Investment Law series, which was referred to yesterday also. It's a series that was launched during the first seminar organized at Leiden University together with Attila Tanzi, Tarcisio Gazzini, and Stefan Schill. And it's also an occasion, I think, not only to discuss the work, but also to celebrate the 20th volume of the series. So first of all, this is a fully online webinar. So many thanks for bearing with us. The book was published and is basically a reworked version of a PhD that Reza Eftekar defended at Leiden University and supervised by myself, if I remember well. Tarcisio Gazzini was also in the opposition committee, as we call it, and acted as an external referee. The plan is to give first the floor to Reza Eftekar to present the book, the main ideas behind the book, and then to offer the opportunity to Filippo Fontanelli to give some remarks. So first of all, briefly to introduce our speakers, Reza Eftekar holds a LLB and an LLM from Shahid Beheshti University in Iran. He has worked in practice as a legal advisor since many years in the private sector, and then since more than 10 years or almost 10 years as legal advisor at the Iran-US Claims Tribunal. And at a certain point in time, he decided to embark on a PhD alongside that function. And this is where the book comes from. Filippo Fontanelli is senior lecturer in international economic law at the University of Edinburgh. He's, amongst others, the author of a book on jurisdiction and admissibility in international investment arbitration, as has acted both for investors and states in investment arbitrations. He's currently lucky to be spending a sabbatical in Abu Dhabi, working for the Ministry of Foreign Affairs of the United Arab Emirates. And in that capacity also is working in international proceedings. So he's well placed, I think, based on his prior research also to offer some remarks on this. I will abstain myself from giving too much praise of the work of Reza, having been involved in it. But Reza, you have the floor to present the work, the book, the main ideas and arguments raised in there, and then we'll give the floor to Filippo Fontanelli.
Thank you so much, Professor De Bravandra, for that introduction. It's a great honor to have your endorsement on the work. Ladies and gentlemen, good day. This is Reza Eftekar. I am the author of the 20th volume of Nijhoff's International Investment Law series. The title of my book is The Role of the Domestic Law of the Host State in Determining the Jurisdiction, Ratione Materia of Investment Treaty Tribunals, the Partial Revival of the Localization Theory. So, as you may have noticed, this is not only the last book in the series, but also it is the holder of the longest title in the series. So, and since I've been given only 15 minutes to present my book, I have to be careful not to repeat the title so many times. Each time I say it will take away a minute. I'm grateful to the University of Trento and the wonderful colleagues who so competently organized this very important seminar, for providing me with the opportunity to present my book to those who are interested in this field of law. I would also like to thank Professor De Bravandra and Professor Fontanelli, who very kindly accepted to appear on this panel. It's a true privilege, gentlemen. And last but not the least, I have to thank Brill for their support throughout the preparation and publication of this book. It's a great honor to have my first English book, hopefully not the last, published by Brill. With all that said, I think the audience is interested to know a little bit about what I have discussed in this book. The idea behind my book starts with a story. In the 1960s, 1970s, the legal scholars of developing countries put forward a legal theory pursuant to which it would be not the international law or the laws of any further state, but the laws of the host state that would govern disputes arising out of foreign investment contracts. Secondly, based on this theory, it would be not international arbitration and not the courts of any third state, but the courts of the host state that would resolve any disputes arising out of foreign investment contracts. So in a sense, the main idea behind this theory, which came to be known as the localization theory, was to dominate the fate of the foreign investment disputes in the hands of the laws and the courts of the host state, these the local elements. This is a very important sentence. I will get back to it towards the end of my presentation. So, and this, the localization theory, was the guiding principle for the governments of developing countries when they were drafting foreign investment contracts and negotiating foreign investment contracts with foreign investors, and also when drafting laws and regulations concerning foreign investment, and when proposing resolutions in international organizations. And this localization theory interestingly, was itself a rematerialization of the Culver Doctrine, which had been advocated and supported a century before by Latin American countries. Now, obviously, this theory was disliked by the major source of foreign investment, the European countries and North American countries. And one could see this inclination towards the theory in the writings of Western publicists, in the awards rendered by European arbitrators, and in the negative and or abstaining votes cast by the governments of developed countries to the proposed resolutions of developing countries' international organizations. All of these steps and efforts by developing countries and their lawyers attenuated the effect and the force of the localization theory. But one particular factor, among others, economic factors and also political factors, which are outside the scope of my work and have to wait for another day, there was a legal factor which effectively put an end to the localization theory, and that was the invention and the proliferation of bilateral and later multilateral investment treaties. Pursuant to these treaties, it would be the laws of international law, the rules and principles of international law that would govern a dispute arising out of an investment treaty, not the laws of the host state. And effectively, the courts of the host state were stripped of any function whatsoever to resolve investment treaty disputes. Those disputes would be resolved by international arbitration. So in effect, the laws and the courts, which were the two pillars of the localization theory, had no effect anymore under this new regime of bilateral and multilateral investment treaties. And after a dense web of these treaties was in place in the four corners of the world, even the most ardent supporters of the localization theory in the third world admitted that in the regime of investment treaty arbitration, laws and the courts of the host state would have no role to play. And that was effectively the end of the localization theory. But my book starts where the localization theory ends. Now, when the tears subside, one could analyze the investment treaty law as it stands today, or contemporary investment treaty law. The question is whether investment treaty law as it stands today is exclusive of the laws and the courts of the host state. If the answer to this question is negative, what is the impact and extent of the role of the courts and the laws of the host state in the resolution of investment treaty disputes? And to this, my book attends. To answer this question, I have divided my book into two parts. The first part analyzes the role of the domestic law of the host state in jurisdictional matters, in particular on subject matter jurisdiction. In part two, I consider the localization theory, and I examine whether this theory has been revived in the light of the recent developments in investment treaty law. In part one, chapter one, I discussed the role of the domestic law of the host state in general. I analyzed various situations in which domestic law of the host state applies as law and as facts. I come to the conclusion that mostly in matters concerning subject matter jurisdiction, domestic law of the host state applies as law, as part of the applicable law to the questions at stake before an investment treaty tribunal. In contrast, in issues concerning state responsibility, remedies, and breach of investment treaty, domestic laws mostly apply as facts. And then, building on that, in chapters 2 and 3, I deal with two specific questions concerning the role of domestic law in determining the subject matter jurisdiction of an investment treaty tribunal. I discussed this in a very great detail, sometimes ad nauseum, the legal basis for referring to the laws of the host state to two questions: the legality of investment and the existence of rights over properties constituting investments. Now, I discussed the legality requirement in chapter 2. What is a legality requirement? If you take a look at the investment treaties, there is usually an introductory provision which says that investments are protected if they are made in accordance with the laws of the host state. This is the legality requirement. The lawfulness and the legality of investment, in other words, have to be analyzed in the light of the provisions of the laws of the host state. There is a direct analog to the laws of the host state. So, in this chapter, I discussed the basis for referring to the laws of the host state. One basis, as I said, is the express agreement of the contracting parties to the treaty that the laws of the host state would determine this issue. But even absent such a stipulation in the treaty, I come to the conclusion that the nature of the issue necessitates the application of domestic law, even when there is no stipulation in the treaty, and there is a chain of authority in there. Then I go to analyze the consequences of the application of domestic law to this legality requirement. And I come to the conclusion that whenever there is an investment which is made in violation of the fundamental laws of the host state, at the time of its establishment, arbitral tribunals should dismiss jurisdiction. And this is what they have been doing in the last 10 to 15 years. Many cases have been dismissed because the investment was found to be made in violation of fundamental laws of the host state. Now, in chapter 3, I discussed the issue of the existence of rights over properties constituting investments. Again, the legal basis sometimes is found in the express agreement of the parties, but not always. This is rarely done in investment treaties. And that's mostly because this is now recognized as a non-controversial issue. The nature of the issue, which is related to the domestic jurisdiction of the host state, necessitates the application of domestic law, internal law of the host state. If the laws of the host state recognize the alleged interest as a property, as a piece of property asset, then the case could go on to the next stage. If not, the case would be dismissed. And again, this is what has been done in the practice of investment treaty arbitration. Again, so two questions: legality requirement and existence of rights over properties. The application of the domestic law of the host state could bring the investor's case to a complete bar, an abrupt end. So this threshold issue, these two threshold issues, are governed by the domestic laws of the host state. Now, that's the first part of my book. In the second part, I begin in chapter 4 by discussing the genesis and the premises of the localization theory. And since I discussed it already, I'm not going to go through it again. But in chapter 5, importantly, I show in the first section the trend towards the localization in contemporary investment treaty law. First, I show that the laws of the host state have gained some important ground that they have lost pursuant to the introduction of bilateral and multilateral investment treaties. And this I show through comparing older investment treaties with newer investment treaties, and also by comparing the older investment arbitration jurisprudence with the newer investment arbitration jurisprudence. I show that the laws of the host state have gained some important roles to play in the last 10 to 15 years. And importantly, in this second section of chapter 5, I identify 4 distinct aspects in which, remember, the localization theory had 2 pillars, the laws and the courts. Now in section 2 of chapter 5, I discuss the 4 distinct aspects in which the domestic courts of the host state have been found to have a consequential and impactful role in the resolution of investment treaty disputes. Their role when they should be referred to before initiating arbitration for a defined period of time. Their role when they have to be referred to consummate the establishment of a breach by the host state. Their role when their findings have to be referred to by investment treaty tribunals on matters of domestic law, and their direct role in the resolution of all or parts of the investment treaty disputes. Now, all of this taken together, the laws and the courts of the host state, the role that they have gained gradually in the course of time in the resolution of investment treaty law, has brought me to one simple conclusion: the revival of the localization theory in parts. There has been a partial revival of the localization theory in light of the recent developments in investment treaty law. Now, that was an outline of my book, and I would like to thank you for your patience and attention, and for providing me with this opportunity to present a more animated version of my book. Thank you very much.
Thank you, Reza. Very good to have stuck to the time frame. So many thanks. It's always difficult to summarize a book in 15 minutes, but thanks for having done that without spending too much time on the title, which indeed is quite long. Anyway, I'm glad to give the floor to Filippo Fontanelli, whom I already introduced before. So Filippo, you have the floor. Looking forward to what you think of the book and questions you might have to Reza.
Thank you very much, Eric. And of course, thank you, Reza. Thanks to the organizers for the invitation, and thanks everybody in the room. I could hear some familiar voices. So first of all, this is a great book. It exists in reality. It is an object. And as Reza already said, has a peculiarity that it has a double feature. It has a first section that is really doctrinal, is refreshingly lawyerly, and a second shorter part that tells a story and traces a trajectory that we can follow easily. Both parts speak to a same core problem, but they can be appreciated and read autonomously. So even if you have a couple of hours, just pick one of the two and you will have spent your time wisely. The book is clearly written. It is very much up to date for the moment. And also meaningfully, I believe, is much more steeped in the practice than the scholarship. The ratio between our words and articles is skewed in favor of our words, which is better in my view. And also, last trivia, Reza was able to create certain hypothetical scenarios to prove certain points and to test certain theories that are masterpieces. I wonder whether he's stolen those from actual practice, because they're wonderful. There's investor A in state B trying to acquire plants under BOT contract that went wrong for many reasons. That's great. Twice a year, I have to create hypotheticals for the exams, and I never get to that level. That's another level altogether. I want to raise 3 thoughts, possibly to elicit discussion afterwards. The first thought is that this book has a virtue that it challenges lazy thinking. One instance of lazy thinking that is relevant today is that we tend to believe that we know what is meant when we read or when we hear or when we say that the law is applied. And the truth is, we assume that because most of the times we don't have to wonder what it really means precisely, but there are circumstances in which to know precisely what application of the law means is decisive. We need to know what it means that a law applies as fact or as law. We need to know the distinction between interpretation and application of the law, because the stakes can be enormous, not always, but when they are, it's important. And the infamous question of whether ISDS tribunal can apply EU law being domestic law in the member states of the European Union, is precisely one of those questions that could be better understood if we paused, as Reza does, and inquire, investigated, probed the idea of application. We went into the quagmire of application of EU law by external tribunal precisely because this notion is not very clear, and we won't get out of the quagmire without understanding it better. And so here I would like to drop a first question for Reza for later a follow-up, especially for those who might not have read the book. How would you distinguish the application of domestic law as fact from the application of domestic law as law in clear terms? What are the indicators that you invite us to look at to be as clear about the issue as you clearly are? Now, the book focuses on one aspect, which is jurisdiction. Within jurisdiction, one aspect, which is ratione materiae, and within that, two sub-aspects, which is the legality requirements and the definition of property rights under domestic law. The first one, legality of the investment, is a popular topic. So it's understandable that it fits into this book, but the real surprising, because it's more obscure topic, I believe, is the one about the characterization of property rights in the various jurisdictions. This is refreshing because this is really something that is taken for granted, but is quite important. And I believe many people here in the room will have had my reactions when reading Zachary Douglas's big book, because that's one of the unique examples in where there is a great discussion on the theory of property rights and rights in rem and contractual rights. And it's so great because it's so relevant to some of the standards of protection. But I think you would agree with me that this is normally ignored. So it was so great to see that this was actually taken up and brought to a point of proficiency. A short anecdote. Many, many years ago, when I was young and naive, I had the opportunity to work on the case that is known as Abaclat versus Argentina, but at the time was known as Giovanna Beccara versus Argentina. And we were in the brainstorming stage, the legal team for Argentina. And we were trying to understand whether sovereign bonds were property rights or contractual rights, because we wanted to see whether there was something to the possibility of challenging the territoriality of the investment. So if they are contractual rights, how can you say they are in Argentina? Because maybe they're in a database somewhere in Basel. So this is all to say, these investigation into property rights that underlie the investments is not for fun. It can have real consequences. And it's true that this book in general evinces that the author is a practitioner, because it shows that there is a craft that is implicit in the reasoning. So the reasoning is not for its own sake. Let me get to the second point. This book systematizes the practice. You read this book, you learn something about how you understand investment arbitration. So in a sense, it's less about correcting the practice, coming up with a solution, and it's more about explaining it, which is a welcome exercise and also a sign of great modesty for what it is, a terrific work. Now, because I'm here, I wanted to tease the author, get out of this humble approach, and could you tell us an example in which you realized that an arbitration tribunal misunderstood some of these classifications, some of this taxonomy, some of these basic rules, and therefore made a bad decision because of it? I'm sure you have found some of them, and you've been very graceful and gracious and not trying to emphasize mistakes, but maybe you can tell us one of them to as a sort of a warning story. We should read your book, otherwise we make the same mistake. The book also has a great deal of sensitivity when it approaches an issue of deference to domestic courts, to the extent that the book explains and demonstrates how important it is for arbitration tribunals to understand domestic law properly. It opens the question on how the identification of domestic law shall operate. So on the one hand, it is very possible to consider the decision of the highest court of the country as the best possible material to identify the law. On the other hand, if you push that deference too much, you clash with the idea that you cannot invoke your own law as an excuse for international wrongful acts. So it must stop just short of that. And you would find in the book the very balanced assessment of these two competing notions. And it made me think, because recently I think we had an example of each case in relatively comparable circumstances. In Italy, the Italian Constitutional Court vindicated the Italian measures that lowered subsidies and incentives for renewable energy producers. And therefore, the subsequent ISDS litigation tries to ignore that decision because it does not matter. Whereas in Germany, the German Constitutional Court vindicated the investor's claim that the discontinuance of nuclear energy licenses was an infringement of private property. Now, in that scenario, conversely, that decision presumably led to a quick settlement in the Vattenfall case. So you can see both notions. Domestic decisions are very relevant to the point of having a dispositive effect on the claim, or domestic decisions can say whatever they want, but they cannot excuse the state. So there's a balance there, and the book explains it. The third and last virtue of the book, among its many, the third that I mentioned, is that in its second part, the part about the relocalization of investment arbitration, it frames relocalization for what it is, a form of state backlash, state reappropriation of the system. Now, why do I say this is a virtue? In the past 10 years, there has been a lot of effort in explaining why reform of ISDS is necessary, as if it were a neutrally objective improvement. So relocalization is there, but it's often sold as an operation to restrain injustice, disproportionate power of foreign investors, a rebalancing exercise that is focused on preventing excess. That can be true, but it's definitely, it definitely has some ideological overtones or layers. So I prefer a more objective view, like the one we find in the book, that relies on certain textual materials. So states are a bit more selfish and they want to skew the system in a way that is more favorable to them. I'm not questioning whether this is a necessary, appropriate, or just exercise. That's not the point. The point is that states are simply doing a recalibration of the system in their favor, and there's nothing wrong in saying it. Now, of course, one of the quickest ways to relocalize investment disputes is to simply get out of BIT or stop concluding BITs with arbitration clauses. This is happening, and this is part of the overall picture. But there are all sort of in-between ways, because sometimes you're just stuck with the treaties that you have and they are difficult to renegotiate. and sometimes they are difficult to exit. I'll give you just another quick anecdote on a topic that might be familiar to somebody with an expertise in Italian litigation. So Italy has been claiming in several cases, this is a matter of public knowledge, so I'm not revealing anything specific coming from my work with the Italian legal team. So Italy is claiming in litigation based on the Energy Charter treaties that the Energy Charter Treaty does not apply at all. So an extreme form of relocalization. Not only do you have EU law that applies to it, but you have only EU law that applies to this kind of relationship and dispute. As an alternative, Italy is ready to say that the ECT, the Energy Charter Treaty, might apply maybe, but not the arbitration clause. And that is an interesting example of relocalization because it doesn't do away with the standards of protection in the treaty, but it just says, if you want to have your ECT rights vindicated, just go to the domestic court. After all, ECT is part of EU law, yada, 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 yada. So you can see steps in the direction of relocalization all over the map. And it's good to have a clear and informed and very proficient account in this book. Now, I'll drop another question and then I'll shut up. Reza, if you had to write a book or an article tomorrow, what would that be about? Because when we do book launches, we assume, we sort of have the idea that you stopped writing these 2 days ago. You probably stopped writing these a year ago. Your mind has been running in the meanwhile. Do you want to expand this? Are you fed up with this? What is your next scholarly project? We want to hear from you. Thank you very much.
Thank you, Filippo. Very, very nice to hear your thoughts and comments on the quality of the work, but also the questions that it raises, and so many thanks. Reza, I'll give you the floor, and then we'll see if there are perhaps some questions from the audience. Up to you.
Thank you very much, Professor Fontanelli. It's a great honor to hear all these kind statements from you. I've written down 3 questions, and I would like to take them one by one. The first one was the distinguishing factor when you're faced with domestic law. You want to know whether it's being applied as law or as fact. Well, first of all, I should say this is an intuitive exercise. You know it when you see it. But we are lawyers. We are looking for concrete benchmarks. I've given this a little bit of thought. I've been thinking about, because this is really mind-boggling when you apply to specific facts. But let me give you some easy examples and some difficult examples. So let's take the case of the legality requirements. You have this provision in the treaty telling you that if you want to verify the lawfulness of the investment at the time of its establishment, you have to refer to the laws of the host state. This is the last legal provision or the last legal rule in the chain that you have to refer to determine the issue. If you have it in the last part of the chain, then this body of law is being applied as law, as part of the applicable law, not as fact. But the other example, assume, let me give you a hypothetical. Assume that an investor brings a claim before an investment treaty tribunal, saying that the fair and equitable treatment, the standard of the treaty, has been violated by the host state because my administrative rights were violated by the host state. The host state violated its own laws on tender process. Now here, the tribunal has to see whether there has been arbitrary behavior on the part of the host state. So it goes through the facts, whether the law was violated by the host state itself. But the finding that the law was violated does not translate into a violation of international law. We have clear pronouncements by the LC Tribunal in ICJ and also by Vivendi Tribunal. So the test that will be applied by the arbitral tribunal in the end would be international law. The tribunal would say, okay, the laws of the host state were violated in the tender process. Was it arbitrary? Was the process transparent? Was the breach egregious? Was the investor given effective rights for asserting claims after the violation? So these are the three things that I said as example. These are all tests of international law. International law acts in the last chain, and the tribunal, when drafting the award, will refer to these factors, which are factors of customary international law to determine the issue. So the criteria would be the last chain to resolve the legal issue, the legal question before the tribunal. And this is very important. This is very consequential. When applied as fact, if there is a misapplication of facts, the decision could not be set aside. But if the domestic law is being applied as law, it should be applied as law, and it is not applied as law, then there will be consequences in the annulment proceedings. It will be a manifest excess of powers if the circumstances so require. But there are more difficult examples. There are borderline cases. It's very difficult to say something firm about them. I give you two examples. The first is that when the treaty provides for exceptions. So there is this fair and equitable treatment standard, but there are exceptions. Now we are discussing about pandemic. Health exceptions by referring to the health laws and regulations of the host state. When circumstances so require, the actions adopted by the host state based on its laws regarding health would be precluded from the breach. So there will be no state responsibility if actions are taken based on the laws of the host state, in compliance with the laws of the host state. This is a situation where you can not easily draw the line between fact and law. Is it the case that the laws of the host state are being applied, just dismantling what has been concluded by the tribunal based on international law regarding the breach of fair and equitable treatment? Or is it just a factual element that has to be taken into account by the tribunal? This is very difficult to say. My tentative opinion would be the first. A second, more difficult example is the conditions for lawful expropriation. One of the conditions for lawful expropriation is the due process. Some treaties refer to this as the due process in accordance with the laws of the host state, the recipient state. Now here, when you go to the laws of the host state to determine whether due process has been observed in the process of taking the investment of the aggrieved investor, it's very difficult to say whether the tribunal is applying this as a fact or as a law. This time, my opinion is that the tribunal is dealing with this as a matter of fact. So these were the easy examples and the more difficult examples. But the line is sometimes hard to be drawn. Now, the second question regarding the mistakes and misunderstandings by certain investment treaty tribunals in the application of domestic law to the matters before them. Of course, I've been trying not to be too combative in my book because some of these awards were rendered by former or current colleagues. So that's why I was hesitating to criticize sharply. But I think I have mentioned some of this in my book with a gentle criticism. If I can give you one example from the legality requirement and one example from the issue of existence of rights over properties. From the legality requirement, I have cited the decision in Sala versus Sala. In that case, the tribunal correctly said that to a certain jurisdiction, it has to ascertain that the laws of the host state were complied with in the process of initiating the investment. But when applying the legal prism just said to the facts of the case, the tribunal just forgot about the laws of the host state. There was no application of the laws of the host state. In that case, there was a falsification of documents. and the facts were manipulated by the claimants in the tender process. But the tribunal did not pay attention to the laws of the host state to say that this law and this law of the recipient state was violated. The tribunal focused on the principles of international law, like public policy, good faith, and the principle that no one should benefit from his or her wrongdoing. There was no reference to the domestic law of the host state, and that's unfortunate. But at the time, as I've shown in chapter 5 of my book, the tribunals were hesitant to apply domestic law in an international dispute. Now the tribunals have become more vocal in this respect. And to give you one example from the issue of existence of rights over properties, there's this case, Pope and Talbot versus Canada. In that case, the tribunal should have referred to the laws of the host state to verify whether there were rights recognized by that body of law. Instead, the tribunal went to conclude an abstract basis on a vague notion of true interests, divorced from any analysis of domestic law, that these are investments, without saying that these, whether these have a footing under the laws of the host state. I have this famous and interesting quotation from the, if I may bring it up, from a case against, a recent case against Kenya, Cortec Mining Kenya versus the Republic of Kenya, saying the alleged investment is a mining license. A mining license is not bricks and mortar. It is wholly the creature of Kenyan domestic law. Its creation is governed by Kenya. So I don't exclude the possibility that that was the criticism of Pope and Talbot versus Canada award, by the way, but I'm not excluding the possibility that the contracting parties to an investment treaty can define actually property, rights over property, assets in the treaty, but they rarely do so in the context of investment treaties. And since they don't do it, the reference to the term property itself, in the absence of any express agreement regarding the application of the laws of the host state in this issue, implicates the application of domestic law. And to find that domestic law, you can apply conflict of laws rules. Classic. This is one of the novelties of my work. I've tried to make peace between investment treaty arbitration and conflict of laws. So to find the applicable law to this issue, you can refer to classic conflict of laws rules to find the applicable domestic law among the possible or all possible applicable domestic laws. And turning to the third question, that was a very interesting, very fit for a presentation regarding my future thoughts. I have actually two things in mind. If time allows, I would love to work on them. One of them is that I would like to further explore the possibility of writing a complete book on subject matter jurisdiction. In this book, I attend to the issue from the angle of domestic law, the application of domestic law to this matter. But I would like to write a full version of subject matter jurisdiction, not only discussing legality requirement and existence of rights over properties, but also the definition of the term investment, which is still halting us even today, and also approval of investment and exclusions from the subject matter jurisdiction. These are the 5 aspects that I would like to consider in a book. And just like the Marvel movies, at the end of the conclusion of my book, I'm writing a few words about the future of investment treaty arbitration. And in that context, I have just left the trace of my thought process regarding what's going to happen in the future. And I raised the 5 programs that are at the stake now for the reformation of the whole investment treaty system. So I would also like to work on that too. What's going to happen in the future? Where is the localization trend taking us? So that's the second subject I'm interested in. Thank you very much.
Thank you, Reza, for providing us with comprehensive and thorough replies to the questions. I'm virtually looking at Marco.
Yes, we are ready. We are ready with the mic. If you want to open the floor, we shall.
We can't hear you well, Marco. There's a bit of a scramble on the microphone.
So
I believe he's saying that we can open the floor. I don't know if
we're ready with the mic. Probably my fault, I was wearing the mask, so sorry. I can invite you in chat as well. But if you want to open the floor for debate, Eric, we can. We have the mic here, and we can.
Yeah, well, our time is a bit up, but maybe it's good to see if there's one question maybe from the audience, and then we can take it further.
So, any questions on the presentation? Any comments? Okay, it seems we are happy without questions. So we have, but I mean, I can testify that we were listening, and we had a room of 25 to 26 people listening to the presentation. Sorry we weren't able to turn the camera, but from this side it went very well. So,
right.
Yeah.
Okay, but I think, to be honest, we can probably round off this panel. I think unless Filippo wants to offer a reaction, but I think the questions were clear, the answers were very clear. To be honest, I'm very, very not only happy to have had this discussion, very proud also of having this book in our series. And many thanks again to Reza and Filippo for presenting, commenting, questioning, and answering on this book. Many thanks also to Marco, Nino again for organizing this and for hosting this book launch. So back to you, Marco.
So thank you so much for this excellent panel. Thank you very much to the author, and thank you very much to Filippo Fontanelli, the discussant. It has been great, and we hope to see you soon in person. Bye. Okay. So, on behalf of the organizers, this brings to a conclusion our seminar. We are delighted. We've been delighted to have you here. We've been delighted it worked also with this hybrid version. Thank you very much again. Thank you all. I hope to see you soon. Meet you soon again. Thank you very much.